Yes, Inspector.
My Lord, just on timetabling, the timetable's rejigged after my learned friends overran, so we finish at 2:30, so half an hour into this afternoon. I promised my learned friend Miss Ford she's going to get at least an hour, preferably an hour and a half, so that's where I'm going this morning. Can I start by going back to a case that I didn't give your lordships and the lady as much help as I should have done yesterday, and that's the Japan case. And so that's so that's Authority Bundle 7, tab 131. And I was so focused on the principles, I should also have taken you to the section dealing with the special circumstances. So just put you back into context. I'm in particular at the passage that bridges the bottom of MS 8981 and 8982. And you may remember we'd got to the position where the question of whether you were claiming damages above the FRAND rate or limited to the FRAND rate was dealt with separately, but special circumstances could have affected both. If you were claiming above, special circumstances could have made that okay. And special circumstances may also have affected even claiming damages limited to the FRAND rate. They may have made it not okay. So the special circumstances could have displaced the general rule that up to the FRAND rate was okay, but above was not okay. And so what I should have shown you as well, I was so focused on the principles, I should have shown you the analysis of the facts in this case. And that starts at MS 8982 at the top of the page. It's section 3. You just see about 6 or 7 lines down. This is the discussion of the special circumstances. And the first thing to note on the facts of this case, the first 2 or 3 lines in this section is that the claim was for damages exceeding an amount of FRAND. And you see in the next few lines, they split it up notionally to say they're considering the 2 types of special circumstances, i.e. any to justify disallowing the FRAND element and any to justify allowing more. And then in section A, so I'm just about halfway down the same page, on the facts, after referring to a series of exhibits, they then set out some offers that have been made. So just about halfway down on MS 8982, Samsung, that's the appellant, was proposing a worldwide portfolio license, and Apple came back and wanted a royalty cap, and then several months later they came back and asked to pay less. It says several decimal fractions, that rather sounds like several orders of magnitude. And then at 3, near the bottom of MS 8982, Samsung had responded not by making a further offer, it simply said, only make a counter-proposal if you're dissatisfied with ours. And then if we go over the page and pick up sub 6 right at the top, little Roman 6, so this is MS 8983, we see Apple had engaged proposing a cross-license for the UMTS portfolio. So they'd engaged on worldwide offers. And if you go down to section B on MS 8983, this is considering are there special circumstances such that they can't even get damages at the FRAND level. And they consider several set subjects in this section. If you can cast your eye down, you can see A, that starts on this page is sufficient good faith negotiations. Section B that starts on 8984 is about timely disclosure, and in fact there are others as well. But if we look at the good faith negotiations, that's the bit on section A in, on MS 8983. And that contains the bit that I think my friend referred to. Right in the middle of the page, MS 8983, you see that the appellant Samsung has an obligation to have good faith negotiations. And below that's a series of factors that leads the court to say, about 10 lines from the foot of MS 8983, that Samsung's attempts to negotiate didn't facilitate the execution of a license with Apple. And included above that is a reference to timing of different offers. So it initially made a worldwide offer. It received a counter-offer from Apple, but did not make a patent-based offer until the commencement of the litigation. However, as you see, the court went on in the paragraph underneath this section, the one beginning nevertheless, so at the foot of the page, identifying factors pointing the other way. It had several conferences with Apple, importantly noted at little Roman 2 at the foot of MS 8983 that basically manufacturers involved in mobile devices commonly enter into portfolio-based licenses. I'm now over onto the top of MS 8984. And the upshot is the end of this section, just above the section labelled B, is that the appellant's attitude in the course of licensing negotiations cannot be proof that the appellant's claim for damages within the FRAM royalty is extremely unfair. So basically it was okay, the negotiations that went on. And the conclusion, ultimately on this, after considering other factors, is right the way through at the top of MS 8986, no special circumstances to justify not receiving damages up to FRAM. And of course, the court then considered the special circumstances the other way round. And what I mean by that is that are there any to justify above FRAM? And that's titled, that's basically the section beginning at C on MS 8986. And the answer is no, and you get the summary over at the top of MS 8987, just before section 7, basically saying none either way, so that the position is that the damages, so the damages under Japanese law is going to be FRAND. And then issue 7, they go on and calculate it. This is MS 8987. Of course, it's just what you're going to get for damages for an individual patent. I'm not going to go through it now, but it does it by reference to global families of patents for the whole pool. Takes the overall aggregate royalty, which I think was agreed at something like 5%, and you just get the fraction, which is 1 over the whole pool. That's what happens in that section. So I really should have taken you through that as well. I apologise for not taking you through the analysis of the special circumstances as well. I was focused on the principles, and but that's the full picture, and I thought you ought to see that. Now, can I move on and pick it up where we left it in that middle of that German case yesterday? Yes. And just to put you back in context, can you take my friend's printed case, which is in Core Volume 1, MS 238. And we were in the case that he mentions in subparagraph 3 there. And you will recall that this paragraph suggests the German case between the parties shows that the German courts have said the FRAND licence doesn't differ fundamentally from a normal licence owed as damages or compensation. And I showed you yesterday that there'd been a little bit of creative editing to get that, and what the case had actually been talking about is the question of the information ordered for its calculation of the FRAND licence, and saying that as regards that it doesn't differ. And you see in this paragraph, he also says the court regarded the burst rates as irrelevant. You see that word appearing in quotes there. And I want to pick it back up where we were to look for the part where he says he gets that from. And the case, just to remind you, is Volume 8, tab 137. We had moved to the section headed BB at MS 9387. That's the section we'd got to, and you will recall that the point that was actually had arisen was whether the patent owner had been complying with FRAND in the sense of the question was specifically the non-discrimination limb, and in particular the judge's perception that this meant a requirement to disclose all of the licenses of any predecessor in title, in this case Ericsson. So that's the context that we were in. And if we move forward to 9 9389, I'm picking up at the bottom, so right at the foot we see the court saying that where the patentee or his predecessor in title has already granted licenses, it must be shown to the opponent that the license offer treats him equally or why it treats him unequally. And so this is the point, it includes the predecessor in title, and it goes over to the top of the next page, MS 9390, in connection with the license offer which has been made. So he has to show them because the license seeker naturally can't know. And that's the view of the German judge in this case. And if we move over to the top of 9391, we see on the first full paragraph that the plaintiff had only dealt with its own licenses in the pleadings. So I'm looking at the bit just under, there's a letter M, about an inch of the way down 9391, and it's the first couple of lines there. And the court says, third line of that paragraph, that doesn't go far enough. And if we go down in this fat paragraph to just about halfway down, you see it wasn't in dispute that there were licenses concluded by the intervener, that's Ericsson, and the judge was saying that in his view, in order to justify the non-discrimination nature, they had to be disclosed. And if we drop down a further 4 or 5 lines, you see that they say that the plaintiff hadn't done this, and mentions that a general reference to the intervener's practice submitted in another case by other lawyers doesn't make specific reference to those facts. So that appears to be saying that some more general explanation in another case doesn't help. And then importantly for my lords and my lady, one sees the sentence about 8 lines up from the foot of this paragraph on MS 9391, saying, equally insignificant are the remarks on what the British Infringement Court did in determining the FRAND licence in foreign parallel proceedings. It goes on, since the Senate, that's this particular court, must convince itself of the freedom from discrimination of the licence offers in dispute. And it goes on and says the facts must be presented in detail to the Senate, which hadn't happened. And the conclusion at the end of the paragraph is that the defendants can claim, it puts it in language of them maintaining the privilege, but that's what it means, they can claim to owe only the FRAND licence fee. And so that, just feeding it back into the earlier discussion of whether the plaintiff can obtain an order for disclosure going to just the damages claim or the account too, you may remember that's the whole point of what this debate's about. What they're deciding is that because the defendant can claim that, the information that can be ordered will be limited to the damages claim. So it can't be the account information, no more than the FRAND fee. So the extra disclosure that they were arguing about, the profits and the costs, was not disclosed, not ordered to be disclosed. Now, the rest of the judgment, starting right at the bottom of 9391, goes on and considers whether they talk about suspension or adjourning the hearing. And that's actually the practice that my Lord Sales asked me about yesterday, where at the end of an infringement case, nothing to do with SEPs, but at the end of an infringement case, because nobody's looked at validity, they normally grant an injunction, but if there's a knockout blow on novelty or something like that, if it's an obviously invalid patent, you have an argument about whether they should suspend it. And that's what's being dealt with in the rest of the section. Now, can we just pause and go back to my friend's printed case? So this was para 156, subpara 3. So it's on MS 238. The second quote from the German case is said to be the word irrelevant, used in a context where the court is saying the burst rates were irrelevant to German royalties. Now, obviously, the first point is I haven't been able to find the word at all. And the footnote that's given there says it's page 81, which would indicate that it's, given that the case starts on MS 9310, it would indicate that we should be looking somewhere in 9391, which is where I've just been showing, my lords and my lady. As far as we can tell, the closest thing that we saw on that page is that sentence where it says that equally insignificant are remarks on what the British Infringement Court did determining the Fran licence. But as we've seen, it's all about a decision on what disclosure is ordered on for the calculation of past monetary relief, and basically a fight about whether the plaintiff had needed to disclose licences of predecessors because of the non-discriminatory aspect of FRAND. And it's in the context of that the court said that it was insignificant that, the remarks that had been made to it as to what the British court did were insignificant. It doesn't say anywhere the burst rates, and as I said, nor do we see the word irrelevant. So in my submission, this certainly doesn't do what my friend suggests in his printed case, and in fact it doesn't assist him and take his case forward at all. So far as Germany is concerned, what you've seen in the cases that help you are the ones that I've already taken you to, and in fact there are more referred to in the footnotes on page 84 of our printed case. I'm not going to take up time taking you to them, but just for your reference, if you look at the footnotes on page 84, it's MS 383, that are broadly doing the same thing. And you've seen from the two that I did take you to, they readily grant an injunction on a national German patent right in a set portfolio, and they do so where the global implementers don't engage in negotiating a global license. Now, that is also reflected in the most recent communication from the Commission, that the Commission as a, I'm not sure whether it's right to call it a jurisdiction, but as an entity is the last of the four in my friend's paragraphs in 156. He mentions the Motorola case, although he doesn't deal with Court of Appeal's treatment of it. And just for your note, it's paragraph 60 of Lord Kitchen's judgment. But he doesn't address the communication here at all. Can we turn up the communication? It's in Authorities Bundle 8, tab 148. So that's MS 9539.
9539.
39. You see that at the beginning, in the introduction, at the top of page 9540, the statement as to the importance of the interplay between patents and standards. And then over the next few lines, one sees basically the explanation that patents provide the incentive for innovation and enabling innovative companies to receive adequate return. And then we also see the benefits of standards, the support of innovation and growth in the next paragraph, and indeed the following paragraphs. At the foot of page 9540, the FRAN commitment is referred to, and the Commission say that smooth licensing practices are therefore essential to guarantee fair, reasonable and non-discriminatory access to standardised technology and to reward patent holders to continue to invest in R&D and standardisation activities. Just pausing there, again you see the balance. The balance is to allow fair access and to reward patent holders. And secondly, the reference to smooth licensing practices, which in fact is something Lord Kitchen drew attention to in paragraph 60 of his judgment, is something that we say is a reference for the need to this to be done in an efficient and timely manner. So it's not contemplate holding everything up for years while litigation is pursued patent by patent or country by country. The next paragraph in the communication, this is the first full paragraph on MS 9541, explains that the evidence suggests that licensing and the enforcement of SEPs is not seamless, and then it draws attention to what are basically hold up and hold out in the next two sentences. They use language of charging excessive fees and free riding, but that's basically those two things. And actually it's worth noting on free riding, footnote 6, it draws attention to how high the economic stakes are. If we look at 9541, right at the foot of the page, the Commission explains that they consider there's an urgent need to set out key principles that foster a balanced, smooth and predictable framework for SEPs. And again, we see that reflects the two main objectives. The first is the provision of an incentive for the development and inclusion of top technologies in standards by preserving a fair and adequate return for these contributions. And the second is the smooth and widespread dissemination based on fair access conditions. And over the top of MS 9542, in the paragraph just above the new heading, is where we see the reservation that it's not intended to be a statement of law. And we see, if we read the whole of that, what it's focusing on is Article 101 and 102 of the treaty, and that's not surprising from the Commission. And the following 3 pages then set out areas where the Commission calls for increased transparency. It might be noting, just as we flick over that, the one at the top of 9544, the proposal for essentiality checks. A point that my learned friend made in his address was that at the moment, ETSI does nothing at all on checking, and there's a proposal here that perhaps something could be done, and that would actually bring it into line a little bit more with patent pools, which you may have seen spoken about, and in fact are referred to in...
I'm sorry, I missed the word.
Pools.
Patent pools, right.
Pools, where actually more than one group put patents together and they can be licensed all in one go. And they often have checks by expert panels before patents are accepted to a pool. But maybe what's worth noting here is that what they're envisaging is maybe doing something, perhaps looking at one patent within a family. That's right at the end of that section. Now, if we go forward to section 2, which starts on page 6 of the paper, which is MS 9545, this is important. It's an attempt to set out a first set of key signposts on the FRAN concept. And the second paragraph explains where the guiding elements that they're setting out come from, a public consultation, an analysis of best practices, some studies and national case law. And you can see the reference to that in particular is to this case, that's footnote 27. I also ask you to just note the reference to the public consultation, which they actually give a footnote to as well, because I'm going to actually show you Huawei's response to that very shortly. If we drop down to the middle of the page MS 9545, you see the mention of efficiency considerations as a precursor to explaining that there's no one-size-fits-all solution. Basically, what can be considered fair and reasonable differs from sector to sector and over time. And at MS 9546, there's an important section, 2.2, headed Efficiency and Non-Discrimination. And this whole section is quoted in Lord Kitchen's judgment. It's paragraph 60 for your note. And the point about there being no one-size-fits-all is reiterated in the second paragraph in this section. And the next paragraph refers to efficiency again and makes an important point. They say transaction costs relating to the negotiation of a license should be kept to the minimum necessary. And that rather reflects what we saw in Lord Kitchen's para 56. I don't ask you to turn it up now, but you recall him saying that it may not be fair and reasonable to require country-by-country negotiation, let alone litigating country by country. And there's mention in this document of taking account of cross-licensing for efficiency too, and that's obviously a reference to the reciprocity thing that we spoke about yesterday. And then the next paragraph, which is absolutely key. Paragraph beginning "in line with," in that paragraph is explained that the same principles of efficiency support the practice of set portfolio licensing for products with a global circulation, and then specific reference is made to the country-by-country approach, which they say may not be efficient and may not be in line with commercial practice in the sector. And you see the footnote is a reference to the decision of Mr. Justice Burse in this case. In my submission, they're clearly referring to and approving, basically adopting what he said. And just for completeness, you see what we've just been discussing covered in the summary of points, in the summary table, the greyed out box on the next page, MS 9547. And in particular, it's the point which is the last one beginning with a dash, so it's just below halfway down that grey box. So can I just draw a couple of things out, if I may? First thing is this: the Commission is concerned about efficiency. It's also concerned with what is normal commercial practice in the sector. So quite contrary to my friend's argument that there's a dichotomy in this, and just on that, I don't ask you to turn it up now, but I remind you that in Huawei and ZTE, the CJEU recognised the importance of commercial practices in the field. The next point I make, just standing back, the whole section 2.2 is directed to efficiency and non-discrimination. That's the heading. And the point is this: unless one's having regard to what's happening in real life in the sector, you will be discriminating. I've made that point already, but I draw attention to the fact that they're making these points in a heading directed to efficiency and non-discrimination. In fact, there's more in this document from the Commission that's relevant to the matters that are raised in the appeal before this court, and that's because of the new approach to argue there should be no injunction available, just damages. Can we go forward to section 3, which is MS 9548? This is directed to enforcement. And the end of the first paragraph is directed to the question of whether injunction should be available. We see in the last 6 or so lines of that paragraph the explanation that enforcement is one of the key aspects of IP rights. It goes on to explain that in the field of SEPs, injunctive relief aims to protect SEP holders against infringers who are unwilling to conclude a licence on FRAN terms. They go on to say, of course, that one needs safeguards to ensure that users threatened with an injunction won't accept terms that are not FRANed. That's the hold-up point. But I think it seems an age ago now, but one of the points I made to you very early on in my submission is that hold-up doesn't actually occur in the process that is adopted in the English court, because there will be no injunction until any dispute over FRAND has been determined. And the discussion moves straight to the Huawei and ZTE judgment, and of course I've also made the point already to you that that judgment itself is wholly inconsistent with my friend's argument that there should be no injunction available, just damages in lieu. It's all about starting actions, claiming injunctions. I also draw my lords and my ladies' attention to the point made by the Commission towards the top of MS 9549. It's the end of the second paragraph, and it's a point that you've actually seen in Lord Kitchen's judgment too. It's in the context of how an implementer responds to an offer with a counter-offer, and it's the expression, or the reference to the expression of a willingness to submit to the binding third-party determination as an indication of FRAND behaviour. I don't just draw attention to that because it's all of a piece with Lord Kitchen's judgment. I say this. In my submission, that is not referring to indicating a willingness to submit to a raft of separate country-by-country determinations. It's a single determination. And this passage also reflects that a licence cannot be delayed. If we move forward, I've already taken you to the section, the paragraph at the top of 9550. The final point on the document I want to show you is just a point on patent assertion entities, just because of the way that my friend puts his case. It's the foot of 9550. This is non-practicing companies, so people that have patents but aren't making products. And I come to this just because there is an attempt in my friend's submission to suggest that there's something wrong about my client's business methods. It doesn't help him, I've already explained that it doesn't help him on his submission because he's saying that the relief that was secured in this case can't be available in any case. But I draw attention to the section right at the bottom of this page explaining that patent assertion entities are entitled to be subjected to the same rules as anyone else holding SEPs. Now, we can put that away, and I'm not going to take you to the next case that I'm going to mention, but I'm just going to mention it to save time. It's to complete the trilogy of the main patent litigating territories in Europe. We are one, Germany and the Netherlands are the other. We've dealt with Germany, but we've referred to a Dutch case of Philips and Asus in our written case, and that is has something to say about Huawei and ZTE too. So I'd invite you to read that aspect of it when you look at it as well. But I don't ask you to turn it up, but just for your note, it's Authorities Volume 7, tab 121, MS 8364, and for your note, it's a case where Philips offered its standard terms to ASUS, who didn't properly engage. They said they were a willing licensee, but didn't do anything to substantiate it. And the Dutch court granted an injunction on the Dutch patent. So basically what I've shown you in Germany. And in fact, a similar approach to that can be seen in the Chinese courts. They won't determine terms of a global FRAN license yet, as you know, but a patent owner making a reasonable global offer can get an injunction to restrain infringement of a Chinese SEP where the court concludes the implementer is not responding reasonably, and that's Huawei's own case against Samsung. And it's an example of Huawei when in the position of a SEP portfolio owner seeking basically to come to this side of the court and adopt all of the points that I put forward to my lords and my ladies. Can I quickly show you the key bits of it? It's Authorities Volume 6, tab 105. The MS number is 7618. And this was a case where there were a series of offers made by Huawei, and you see that from MS 7685. right at the foot of the page. They were in fact all global, as Mr. Leighton, Huawei's counsel in the Court of Appeal, confirmed. And one can see it, for example, as regards the first offer that they deal with first. The key bit is in fact over on page MS7687. You see about a third of the way down the page it says region global. The others are all the same. Most are expressed like that to be global or worldwide. Some of them you have to read to see how the royalties are calculated, because they're calculated on global sales. And in fact, I think the sixth one's rather heavily redacted, but as I say, it was confirmed by Huawei's counsel that they're all worldwide. And what the Chinese court did was considered whether Huawei and Samsung had obvious fault and had complied with FRAND principles in two ways, both procedurally and to the substance of their proposals. And if we go forward to MS 7797, what you see there is the procedural matter addressed first, and you see the heading at the top of the page. And in fact, this is another one of these courts where they tell you what they're deciding right at the beginning of the section and then give you the reasons. So you see the heading at the top of the page, and the summary of the conclusions comes first. Samsung was at fault and Huawei was not. And if we skip forward to MS 7810, you see the question of obvious fault looked at on the question of substance. The heading is at the foot of the page. And the paragraph that follows summarises the conclusions reasoned in the rest of the section. And over onto the top of the next page, MS 7811, Samsung had violated FRAND while Huawei had not. So that's both procedurally and on substance. And the result of the case, very quickly, is MS 7828 at the foot of the page. An injunction enjoining infringement of a Chinese patent in issue. Can I very quickly show you the Advocate General in Huawei and ZTE while we're on the law? It's Authorities Volume 6, Tab 106, same volume. And it's paras 94 to 95 on MS 7882. My learned friend actually took you to bits of the Advocate General's opinion, but he didn't actually make it clear when you were in the court or when you were in the Advocate General. I think he took you to some pages earlier in the paragraphs around 65 and so on. It's the same opinion that he took you to that I'm showing you. And the reason I'm showing you these two paragraphs is the view being expressed here is that the implementer can reserve the right following the conclusion of a license to challenge validity or use, i.e. infringement, but not before. And the key words for my lords and my lady to note is the word following in paragraph 94, and the words in paragraph 95, the words after concluding a license agreement in the third line. Very quickly, Huawei's own response to that public consultation that you saw referred to in the footnote in the Commission communication. That's actually at Appendix Volume 5, 15 17, and the MS number for that is 1990. And the reason I want to show you this document is that it specifically addresses injunctions. It was key issue 8 in that consultation. And if you go to MS 2002...
I'm very sorry, I've just got the hard copied book.
1529.
Thank you.
The way they answered it is in boxes, and you should see in grey, key issue 8. 1529. And so you see what Huawei has to say in the section headed Unwilling Implementers and Injunctions. And the very first sentence is, the pursuit of an injunction is generally permissible. And they suggest it can only be seen as abusive when the user of the SEP, i.e. the implementer, has made a binding and irrevocable offer, and that offer must either identify the specific terms that are FRAND or agree for a determination of FRAND terms by the court or an arbitrator. And if you go to the foot of the page, you see the detail is explained as having 2 essential elements. Over the top of the next page, MS 2003, which is 1530, the first is the binding offer by the user, and it can be in specific terms, and then it says in the first bullet point that patent court must determine whether they are FRAND, has to determine FRAND. At the end of the bullet point says the rejection of the offer, that is obviously the rejection by the patent owner, would lead to no injunction. So far, so good. And the second bullet point is that offering to be bound by the court determination or an arbitration, and they say this points out how difficult it is to hit the nail on the head. And again, Huawei says if the patent owner rejects this, there would be no injunction. The second essential element is the ability to challenge validity and infringement, and this is the passage just around halfway down on MS 2003, so the same page. It says the patent user cannot condition its offer on a prior finding. That will unduly delay the conclusion of a license. So that's mirroring what we saw in St. Lawrence about not holding, basically conditioning the license on a prior challenge. And the upshot of these 2 essential elements is explained at the bottom of this page. The injunction can only be abusive where the user has not made a binding offer of the kind it's been talking about. Conversely, a SEP owner must be able to prevent the use of its patent through an injunction where it's not done so. And so over the page, you see how the SEP owner, how the SEP owner is protected because it can secure the FRAND license, or where the user is not willing, it can enjoin on the patent, can enjoin the use of the patent, and the SEP user can protect itself against misuse of an injunction likewise. The last paragraph in the box is worth noting because what Huawei say is this. They say that what they're proposing is in line with the content of the FRAND commitment, and they quote it. Please note well that what they say in the last 3 lines in the box. The patent owner doesn't undertake, however, to tolerate the use of its patent without a FRAND license and to limit itself to the pursuit of damages claims. But that's precisely the submission that my learned friend makes to you. Final point to note on this document is just box 8.4, right at the bottom. They say they're not aware of any jurisdiction that's banned or restricted injunctions. And they explain in compelling terms why they should not do so. So, my lords, my lady, I've turned up quite a few foreign cases, some regrettably just in order to show you that they don't do what my learned friends say, but others to show you that the weight is against the key planks of my friend's argument, and actually they support mine. The direction of travel is entirely consistent with what Mr. Justice Burst and the Court of Appeal have done below. The final point on, as it were, foreign courts and comity is to address Mr. Block's suggestion that there will be issues of foreign competition law as a reason for the national courts not to deal with it. Now, the first point I make about that suggestion, it's entirely speculative that there's any problem at all. No particular law or laws causing an issue have been identified. And I also draw attention to the fact that it's rather inconsistent with my learned friend's acceptance that a global licence is justiciable and it is the right approach. As I've understood his submissions, he just says only in the right court. But the point that he makes would be applicable wherever you do it, because if it's global, there is the potential he seeks to identify for all other jurisdictions. So it may be raised to defeat global licensing anywhere. The second big point that I make about this is the objection, if it's good, would also be a reason not to allow consensual agreement. And that leads me to the next point, which is that actually the point of our exercise is to reflect those real commercial practices, i.e. real consensual licenses. And I go further and say, insofar as there are any points, such as the lower rates in China, that my friend relied on, not as a competition law point, but just as reflecting economic policy, they will be priced in and reflect what real people do. So you'll be able to look at, or you get the effect of it by looking at what the real people are doing and looking at comparables. The last point on this section is to deal with a suggestion that was made that somehow there were different methods of assessing FRAND, and I think they even went so far as to say FRAND meant different things in different places. That's not right in my submission. There is a single obligation. The fact that in different courts you may see different approaches to assessing FRAND is actually no different to the fact that in the English court, in another case, depending upon the circumstances and the evidence, you may see a different approach. That's because in the real world, there are different approaches to assessing value. All it's doing is reflecting what may be the appropriate way to assess value in the circumstances of the case and in the light of the evidence and the arguments advanced. But you're doing the same thing. You're carrying out assessment under the same obligation in each case. Now, I've taken that last bit of the section on the law at quite a canter. I wanted to move on to issue 2, which is forum, unless there's anything else that my lords and my lady would like me to help you on.
It appears not.
So issue 2 is forum, and you know it arises only in the conversant case. And I've got on this issue 2 big picture points or propositions. And the first one is this. Forum conveniens is about requiring a claimant to bring the claims that it chooses in the appropriate competent forum, assuming there are multiple competent fora. Forum conveniens is not about restricting which claims a claimant may bring. In short, it's not about which claims, it's about where to adjudicate those claims the claimant selects to advance. My second point is this. Forum conveniens is concerned with what other competent fora are available. It's not actually concerned with whether anything is actually litigated there. There need be nothing on foot already there, and the claimant need not pursue his claim in the alternative forum. And that is in contrast to case management powers, insofar as relevant to this debate. That is about what is happening elsewhere. Now, can I start with some introductory remarks? What my friend is seeking to do by this application is to prevent Conversant bringing the claims that it has available to it under patents around the world. It's seeking to stop us doing so. In this case, the application is for an order setting aside the claim form, the particulars of claim, service thereof, and any other documents in these proceedings. And let me just show you that. It's in the supplemental bundle, tab 26, so that's MS 10825. I'm just going to show you the Huawei one. You see in the box down at the bottom on page 10825, Para 2 is in fact the justiciability application. Para 3 is the forum conveniens application. You see what they want is the claim form, particulars of claim and service thereof, and all other documents in the case against the first defendant set aside. Just for your note, the ZTE version's in the next tab on 10828. And so in this case, pending this appeal, no acknowledgement of service has been filed, only that initial one where you tick the box challenging jurisdiction. And the position of the appellants remains that everything is to be set aside. Every letter we ever get, all progression of the technical trials, all of it, always subject to this jurisdiction objection. In fact, what happened is the defendants has secured a big delay just by making the application. I think it's between July 2017 until April 2018. That's how long it took for it to come on and for there to be judgment. And we complained about this to Mr. Justice Henry Carr, because obviously delay in these cases causes prejudice, and we said we should be getting on exchanging pleadings and so on in draft. And we had a hard-fought argument, which fortunately we won. And so matters have progressed, but everything is in draft. That's why all the pleadings, if you ever look at them, are labelled draft and filed with reservations on jurisdiction. Our learned friend Mr. Alexander even called the technical trial in one of the UK patents that we did against each other in the summer a draft trial. Everything is challenged as a matter of this jurisdiction application. So before we get into the detail, it's a remarkable consequence of my friend's application that he says my client is prevented from even seeking to advance claims to enforce its standard essential UK patents in the UK courts. And in fact, as a matter of logic, if the position were mirrored in other countries, they'd be prevented from seeking to enforce their essential patents in all other countries where they've got patents registered, save perhaps one. And it's even more remarkable because it's a case that because validity is challenged, as it always is, there is no other court that a claim to enforce UK patents can be brought. Here is the only court. And I'll just remind you, I don't ask you to turn up the Spiliada, but if you cast your eye back on it at leisure, the discussion there is all about available competent courts. Here is the only court. It's a court with exclusive jurisdiction. And you see that point identified by Mr. Justice Henry Carr at the end of paragraph 27 of his judgment. I'm in Core Volume 2 at MS 851. Right at the end of paragraph 27. Now, before I go further, a few other key matters of background. Something that I know my Lords and my Lady have got well in mind, that Mr. Justice Carr held China would not determine the terms of a global FRAN licence, and in fact other issues that he identified in that key paragraph, paragraph 61. And those findings of fact are fatal to my friends. But I make a further observation. China has done whatever it has. Mr. Howard likes to tell my lords and my lady of his success there. Yet he's still maintaining in these proceedings that they should be stopped here. And as I understand it, something, I don't quite know what, sent back to China, which as I understand it would be an action full of exclusively non-China issues. So leave aside the fact that there's a finding of fact that court won't do it, but I think his position is that something which is exclusively non-China should be sent back there. The second or further matter of background that I want to just cover with you before I outline the correct approach is the suggestions made by the appellants for litigation in China before the judge. I think you've probably picked up that both ZTE and Huawei are pursuing Chinese claims in different Chinese courts. And so the proposals were, in fact, that Conversant agree to two different cases in China, two parallel Chinese proceedings. And it wasn't simply an offer to submit to the Chinese jurisdiction of the claim being brought here. They're offers to construct some kind of framework of presumptions to litigate in China. And the central point of them was to stop Conversant seeking to enforce its patents outside China. The offers weren't even the same. So we're being offered different frameworks of presumptions to litigate in two different Chinese courts, the terms of which wouldn't be the same. And more importantly, they're just presumptions we didn't agree to, and involved asking the Chinese courts to do things which the judge had found it wouldn't do. But this is not a case of simply saying, here's another place that you can bring the claim because I waive my right to be sued here. It's nothing like Zambia in the Lungo case. It's an attempt to construct an independent set of rules or presumptions in fact inconsistent with each other because they're different, to suggest some other basis upon which we should agree to litigate. And can I just show you that? Let me turn up ZTE's offer. It's Appendix 4, MS 1970.
Sorry, it's the same request
I
from...
realise I've got to get you...
Sorry.
Not at all. 1498.
Thank you.
Sorry, 1497.
Yes, thank you.
And I just draw attention to Para B, the Chinese patents to stand as proxies for non-Chinese patents. And if you go over the page to 1499, MS 1972, you see the Huawei offer. First paragraph of the text there, for the Chinese court to determine essentiality infringement of the whole portfolio. So that includes UK patents. In fact, all our non-Chinese patents.
Sorry, what page is this? 19?
MS 1972. It's headed statement, but what's in the substance of that is
Oh, I see.
an offer.
Yeah.
And I'm looking at the first paragraph under that. And you see that that is put forward if conversant were to agree not to persist in the litigation, so directed to stopping us pursuing the claim here. But then we see at the bottom something rather strange, that they were reserving the right to challenge validity in these proceedings. So I have to say, I never really understood this, because they seem to be suggesting the proceedings stop, but then they wanted to challenge validity in the proceedings. I mean, it's true that both of these offers were directed to the aim of stopping the claims before this court, stopping the claims in toto, just as the applications are. But they are conspicuously not simply an offer to submit to any other jurisdiction the claim brought here. Now, can I move on to what forum convenience is actually about, some of the principles? I've given you the big picture points. It's about whether the court will entertain the case, the action, the claim, whatever word you're using for that thing. If another jurisdiction is considered the forum convenience, the United Kingdom court doesn't entertain the claim, and you get the kind of order that they seek, that I've shown you. And I'm leaving aside the niceties now as to burden of proof and the differences on service out cases. And in fact, the idea was explained very clearly in the courts below by my learned friend Mr. Layton, who was my learned friend's predecessor. And it's simply this: the court declines to determine the claim because there's another court, the forum convenience, that is available, and it leaves the claimant to bring the claim there. It doesn't compel you to do so, but in effect what it's saying is if you want to bring that claim, you must bring it in this other place or not at all. I'm assuming the fight is just between two. And so the proceedings in this jurisdiction just come to an abrupt halt. And that's why my first proposition to you is that what it's about is where a claimant may bring the claims it chooses to advance. It's not about telling the claimant which claims it may advance. And of course, it's nothing to do with the merits of the claim. Where an application is successful, the action just comes to a halt regardless of the merits. Now, what went wrong in the courts below, according to my learned friend? I have to say I'm not really sure what error of principle they say they've identified. But we say, as we did below, the key to working out the answer on forum convenience is properly understanding what you mean by a claim, how one correctly characterises the claims advanced in these proceedings. Just so you see the big picture, there are 2 points to keep an eye on. One is the difference between a claim and an issue. They're conceptually different things. And in particular, one of the things that you need to keep an eye on is that it's possible for an issue to arise in more than one claim. And the second point is describing or characterising a claim in a way that is inapt. So I want you to keep an eye on that, in particular seeking to describe the claim at a level of generality that is in truth a class of claims. And that's how my friend's argument manages to get into a position that we've been talking about, actually preventing large swathes of claims from ever being brought anywhere at all. Now, we say a claim is just the totality of the facts and circumstances which entitles a person to come to court and secure relief. It's the cause of action.
That's extracted from law on limitations, isn't it?
Is that the Latang and Cooper?
Well, I'm not thinking of particular cases, but I think it's also in the rules. And
That issue arises in...
Yeah.
Yeah.
Yes, it does.
Yeah.
And I think that sort of definition emerges, but I wonder if it's not specially formulated for that sort of problem.
Maybe not, but it works for... The real issue is, unless you're talking about the totality of that which you can bring to court to get relief, you can't actually talk about sending it all off for another court to decide whether to grant relief. And I'm certainly in my submissions going to use the word claim for that thing. And I accept it brings in issues and matters that may be raised as a defence. But I want to point out things that are conceptually different to a claim in that sense. Firstly, a request for a particular head of relief. So something that in the English court procedure you would conventionally put as a paragraph in the prayer. Of course, in a sense, one can say you've made a claim for, say, in a copyright case, additional damages, if the pleading lists it in the prayer. Or typically, in IP cases, including patents, you can include in the prayer a request for an account of profits or a request for delivery up. You can call that a claim, but it's not a claim that we're talking about. The legal complaint made or the cause of action advanced. And in fact, we know from Re Howard's Buenos Aires that it's wrong to look at the precise release asked for. Wrong to look at relief that's only available in a particular jurisdiction. And it's actually broader, that point, than simply saying it's pleaded in terms which are not forum neutral, i.e. by referring to a specific act. In that case, it was the Companies Act. The point can be, and in fact was in that case, that that particular kind of relief wasn't available elsewhere at all. So the actual substance of that case isn't about calling it something under the Companies Act. It's about the minority buyout not being available. I know my Lord knows the case well. That's what it's about.
Written on my heart like Calais written on the heart of Queen Mary.
But I actually rely on that to say it's not about claims in the sense of what you might add in your prayer. Argentina was the place to go, even though that paragraph in your prayer for relief just couldn't be there, however you framed it. The next thing that conceptually is not the same is the wider conflict between entities, say two groups of companies. And that wider conflict may be a whole series of possible legal claims that may or may not be advanced. And certainly in the IP arena, you have all sorts of national, for instance, trademark disputes, which may also bring in possible claims in passing off in common law countries or unfair competition in others. An overall conflict like that is not a claim. And of course, the key distinction I want to make is with an issue. An issue may be a particular point of controversy in an action. It could be a primary point of fact or some more complex multifactorial assessment. It matters not for my point. Conceptually, an issue is not the same thing. Of course, an issue may arise as part of a claim, and determining it may be indispensable, but it is not the claim. And we gave you an example, I don't want to labour it now, but we gave you an example which has actually been given to the Court of Appeal. It's para 36 of our case, page 8 of that document, MS 425, which was an issue that may arise under a patent licensing dispute internationally, which would then, would arise in a patent license, which would then have an impact in every national court. Just from your note, it's MS 425 in Court Volume 1. It's the point about whether a product fell within the definition of a licensed product. So if you've got a license that says licensed product is XYZ, and you bring out a new product, there may be a fight about whether that's licensed, and somebody gets sues on the patent. And that issue could arise in a national patent action all around the world. And just for your note, Lord Justice Floyd refers to this in paragraph 85 and accepts its relevance at 105 of the Court of Appeal judgment in Conversant. And in that case, you don't ask, when considering a forum issue, whether a different claim on a different patent could have been brought in a different country. As I keep saying to you, forum conveniens is not about different claims that could be brought, even if they might be claims where there are common issues. Now, can I move to the correct characterisation of the claim? There are 3 key points in my submission about UK patent infringement claims in cases like this. Just to reiterate, they're as follows. Patent owner alleges the implementer is infringing specific UK patents declared as essential. That's 1. 2, the Etsy-Frand obligation is relied upon. Particularly, it's said there's been a failure to offer a Frand licence, and that means the patentee is not entitled to injunctive relief restraining further infringement. And 3, the patentee alleges that the contractual obligation has been met, and usually the fight that we're talking about here is by a particular global licence.
Part of the problem may, I don't know, but on a very straightforward view of a case, you might say these are UK patents. You're seeking an injunction for infringement of UK patents. Those are all matters, and there's a dispute as to the validity of the patents. Those are all matters within the exclusive jurisdiction of UK courts. The way the case, I'm just looking for the first time at the pleadings, and the way it's been pleaded, it's only by way of an amendment that you've sought now. You're now seeking an injunction. And the way the case was originally pleaded, you were narrating infringement, but seeking to have it established that you had complied with your Frand obligations, that being a matter that was in dispute, and indicating that if you were successful in having it declared you'd complied with your obligations, then relief for patent infringement might then follow. And one could see there's more of an argument about whether the UK courts are the most convenient place to litigate the question of compliance with the FRAND obligations. At least that's open to, at least it's not a matter of exclusive UK jurisdiction. Whereas once you start focusing on injunctive relief well, any form of relief for infringement, then you're on solid ground.
Exactly. 2 points that I'd make to my lord is that that amendment has been allowed, so
Yeah.
that's the case that you're now dealing with. But secondly, what you're really getting at is that if you've got somebody who truly is a willing licensee, you might have a kind of case where, in fact, they might be asking for specific performance.
Yes.
So really, you could be, everyone's agreed that they want the license, and then there might be issues as to where the contractual obligation should be determined. But in fact, what turned out to be the case here is that we thought that they were, in the light of the negotiations, because they always say they are, and then they turn out not to be, because they say they won't abide by any ruling.
Yeah.
So you now...
Yes, I see also that, I mean, the way the case is being argued on behalf of the appellants, the issues relating to licensing are being characterized as being essentially to do with patents rather than essentially to do with contract. And if you look at it in that way, then there's obviously more of an argument that the place where the patents are registered is the appropriate forum.
But also what they're really doing, when you look at the way they argue it, and this is cutting to the chase, they're doing exactly what they did below, which is to try to characterise the claim in a way that generalises out to describe a series of claims. Below, we had things like their claims for infringement of a local patent. And that's just a way of describing any claim under any patent. Now the way it's put, and it's exactly the same, is to say it's a claim for an injunction unless worldwide royalties are agreed to be paid, or something like that. They frame it like that. And if you stop and think about it, firstly, they are accepting that it's to do with the injunction as well. And secondly, they're doing exactly that which they did below. The generalising out is all done by just using the word injunction instead of saying an injunction on what patent. So that's all they're doing. And we've just got exactly the same thing happening again and again as to what happened below. So I can't really do any better than Lord Justice Floyd in explaining this. My lords and my ladies might not be surprised to hear that. It's paragraph 101 and 102 of his judgment, which is in MS 575 to 576. You see what Lord Justice Floyd explains, contrasting it to the Harrods case that he just mentioned in paragraph 100. So I'm now in 101 to 102. The idea of leaving conversant to sue in China would be to compel a case based on different patents. They're not UK patents viewed through the lens of Chinese law. They're different property rights registered in China, different claims, different prior art and so forth. Just a different claim. Mm-hmm. And so Lord Justice Floyd's conclusion at paragraph 102 is it's not legitimised to generalise out the characterisation. That's why what I say is this is all about trying to formulate some words which generalise out to something which is not the claim. And just to give you the notes where they try and generalise out, but basically doing the same thing in their case in this court. I think, if my note's right, MS 245 in Call Bundle 1 In fact, what I draw attention to first, if you go back to MS 243 and look at paragraph 168, when they're not focused on trying to do the generalising out, they rather slip into what you might think is a more natural description of the claim. Here they're limiting it to the relief, so it's not quite right, but it's at least less objectionable. There, where they're not actually focused on trying to pull this trick, they describe the claim as an injunction restraining UK patent infringement. But if you go forward to para 172, this is the top of MS 245, you see what I was just trying to refer to before. What they say is the claim is whether an injunction should be granted unless worldwide royalties are paid. It's a new way of trying to do the same thing. It's just, they're not going for the local patent description, they're just saying an injunction. But the injunction that they're meaning there is obviously intended to mean a whole category of different injunctions on different patent rights around the world. I mean, paragraph 173, they try a different way. It's not even the same, but they try a different way, is whether conversant has steps that Huawei is infringing such that Huawei should take a global license. I mean, of course, the case doesn't tell them what they should do, other than they shouldn't infringe. If they want to take a license or submit to the injunction, it's up to them. But the point I make here is that all they're doing there is, again, just trying to generalise out to a whole host of claims. So that's the guts of what the application is doing, is trying to limit us so that we can only bring claims in China on Chinese patents. And that's just illegitimate. That's not what forum conveniens is about. Now, how do I answer the point put against me as to the risk of inconsistent judgments? You've seen in our case, we've explained that the courts obviously have a case management power to stay issues. And what I say to my lords and my ladies, it's no different to any other case where an issue may arise in the claim here and in another country. So in the example we gave to the Court of Appeal, which is not a set one, where you might have that licensing issue in a patent action here, in a patent action elsewhere, there may be a case management squabble to be had about whether we press on here or there's somewhere else that's more appropriate to determine it. And that's where the point that my second proposition that came in, those case management issues are about what is going on. There's much more flexible in that you can look at particular issues, but it is about what is going on in other jurisdictions.
Could it be about what ought to be going on in other jurisdictions?
It could, if somebody, for instance, turns up and says, I'm going to start an action to do this. So when I say is, includes, it doesn't have to be now. If somebody says, I am going off to this court and it's going to start next week, I absolutely accept that. But when that were to arise, it wouldn't be declining jurisdiction over the claim. You wouldn't be saying you can't sue on your United Kingdom patents. You might be saying, in this claim, that issue we won't deal with at the moment. You make a case management decision. And in fact, that's not very different to what Mr. Justice Henry Carr did in this case. It didn't require a stay because of the timetable. But Mr. Justice Henry Carr took account of the fact that proceedings in China, I can't remember whether they had been started or they might just about to have been started, so it may have been a point that falls within my lady's example, actually. And he decided because he was timetabling technical trials first and then a FRAND trial, that it was being timetabled so that whatever happened in China, we'd know about. So there was no need to actually stay, but as a matter of case management, he directed the trials in a timetable, which is in substance doing the same thing. Now, just as an aside, although the application isn't for a case management stay and it's not the same thing, Lord Justice Floyd dealt with that anyway on the facts and rejected it. It's paragraph 111, MS 578, and there's no basis for this court revisiting that.
Why was Lord Justice Floyd dealing with a case management stay? Was that in fact an issue that was raised in the Court of Appeal?
A bit like it's raised here, that was floated as something that my learned friend Mr. Block, very much in front of you, my lords and my lady, were suggesting that might be an alternative. And I don't think it was any more, my recollection is it's no more than it's just suggested, oh, perhaps you could do that anyway, even though it wasn't the application.
Can I just ask, was it in the Court of Appeal skeleton arguments as an issue, or was it just raised orally?
It might be. I will make sure I give you the...
Thank you. It would be
I
useful
don't
to
want to
know.
answer my lord off
No,
the top
I
of
understand.
my head.
I mean, Lord Justice Floyd's analysis is that the FRAND license under the Chinese patents wouldn't do the whole trick. But is that a sufficient answer to a case management proposal that it'll do a substantial slice of the trick and make the FRAND trial back in the UK in due course probably shorter and more reliable in terms of not having to build in some adjustment clause to deal with a subsequent problem?
Don't forget, he was looking at it having benefit of what Miss Justice Carr had done. And the point that I was just referring to is the timetabling was such that the FRAND trial will happen after China anyway.
Where do we find that timetable? It's a draft timetable, presumably.
Well, it's a draft timetable. We've even had 2 trials now. The last one finished on day 1 of this appeal, I think.
Yes.
We'll find the order. But basically the way it worked was the technical trials first. So the FRAND trial was a fair long way down the line. And I can't give it to you stood here, but I'll find you the order and give you the reference.
I mean, the line may get shorter if the first technical trial identifies a valid and infringed patent. For this, well, no, but if it were to, or the second one, I mean, as I understand your submission yesterday, once you find one, that may be a sufficient peg on which to hang your injunction and render the other technical trials unnecessary.
Well, what happened in Unwired Planet was certainly where one had gone through appeal, the parties agreed that that was so.
Yes.
So not just a trial, you have to have an appeal.
Yeah.
So this is a prospect of it being undone.
Yeah.
But that's definitely what the parties agreed in Unwired Planet. But I mean, the point I make to my lords and my lady is that this appeal doesn't concern an application for case management stay. The reason we're talking about it is because I'm explaining to you why that is the answer to the point put against me on forum convenience.
Can I just check? That's right, is it? There's just no case management issue raised in the notice of appeal to us?
I believe so. The issue 2 is a forum convenience point. There's the agreed issue. Certainly I hadn't noticed it when I read it, but I've been focusing on the issues in the agreed statement of facts and issues. And
Perhaps that could be checked.
Sure. And I've shown you the application notice.
I suppose you would say the essential distinction is you can't really case manage a case unless the defendants have submitted to the jurisdiction and are bound into the management process that's underway.
Exactly.
I mean, there's a sort of draft case management process going on where they're sort of bound in subject to a non-submission to the jurisdiction. Is that right?
What I do recall is that there was an attempt to raise a case management stay as an answer to the Owusu point if the
Yes.
forum challenge had succeeded against one of the defendants but not the other. So it was not a freestanding case management. It was a way of trying to deal with the other defendant. And I don't want to mislead you. My recollection is I think they tried to amend the application notice and that was refused because the point was held to be a bad one.
I mean, certainly with case management issues, you usually expect there to be evidence about what is happening.
Exactly.
And presumably, well, I don't know, was there evidence directed to exactly what was happening, what issues wouldn't be dealt with and when?
Yes,
China?
there was because of the offers that were made. The offers that were made about knocking out patents in China.
Right.
So there definitely was, and that's the basis upon which Mr. Justice Henry Carr was able to say the Fran trial can be whenever it is because whatever's happening in China will be dealt with by then. So there definitely was evidence about what was going on in China.
Right, thank you.
The listing of the trials is in the Statement of Facts and Issues.
Ah.
Paragraph 51, MS 136. MS 136, paragraph 51. It's the fact pages.
So that the Fran trial is not that far away.
Not now,
No.
but this was timetabled in April 2018.
But the parties must be deeply into their preparation for the Fran trial by now.
Can I deal with the UK defendants and the Owusu point, unless there's anything else that I can help my lords and my lady with? It's a very short point. You have to be a bit careful.
I just wonder whether I could just raise a point and say that Mr. Speck does deal with it, so we ensure we're not shadowboxing. Discussing the case management, of course, the position is, as you know, that there now is a judgment in China, both which has determined validity of the patent portfolio and also the rate for such Chinese SEPs as there are, namely one, subject to validity. What is not at all clear whether Conversant accepts, for the purposes of the Fran trial, that those determinations, subject of course to any appeal, but those determinations are binding and conclusive, both as to what SEPs they have in China and what royalty is payable.
That would be a matter for argument in the Fran trial. There are things that crop up, issues about how a rate where there's no other terms in a license may fit into a license, where there are other clauses like the consent and the agreement not to sue customers and so forth. So it's a different thing when it goes into a license, but I certainly accept, as Mr. Justice Henry Carr said, that the judge will want to take account of what happened there.
Well, I suppose the relevance of a Chinese judgment may be a matter of argument, but the conclusion reached, subject to any appeal, the conclusion reached as to the validity of the Chinese patents and so forth, presumably will have to be accepted.
Oh, exactly that. I think my friend was asking more about the rate, but certainly the conclusion ultimately reached on validity and infringement.
So, I mean, given the presence of the existence of the Chinese judgment, is case management now an academic point?
Yes, I think so. And it rather ties in with the point that let me say this, it's not academic for future cases.
No.
In this and so that's why we're debating it, because I'm explaining why it's an answer to my friend's point. But on the facts of this case, yes, I agree. And that really ties into the point that I made about what's he asking to go back to China. China's done what China will do.
But for future guidance, it remains live.
It will be something that can be
Yes.
debated. And it will be just like the point that I put to my Lord Reid. If somebody were seeking an order for specific performance, an implementer, you can quite easily see that there might be a dispute over where that could go. Now,
Can I just check, is the shadowy process, which has led, for example, to the trial timetable, one in which both parties are actively participating subject to the appellant's non-submission to the jurisdiction?
we've had 2 trials.
Yes, but they've been properly fought out trials on both sides, as I understand it.
Mr. Alexander was there
Yeah,
fighting about,
Yeah.
I didn't do the second one, but the 2 of us did the first one, and he duffed me up.
Can I just quickly, on a point of information on the academic issue, is there scope for an appeal in China?
Yes, I believe so. And I think there is an appeal.
Right, so does that mean it's not necessarily completely academic because you're still arguing about things in China?
That might be right in terms of timetable.
Yeah.
There is scope for an appeal. Yeah. Can I deal with the Owusu point? We need to be a bit careful what I mean by it. First, Huawei seeks, in its written case, to maintain the argument that Huawei UK can secure a stay on forum grounds. Previously, it had been put by what Mr. Leighton below had called reflexive application of Article 24.4, which was the prohibition on claims on foreign patents. The problem has always been that he's wrong about it being a claim enforcing foreign patents, so it didn't get off the ground. Now, as I understand it, Huawei basically seek to run the same thing, but not ZTE as I understand it. But the point is still misconceived because it isn't a claim to enforce foreign patents for all the reasons we've been through on the issue 1. So that really isn't the point. The Owusu point really is a related issue, and it's this. It's the extent to which the fact that there's a mandatory nature of a claim against Huawei UK is a factor in the assessment as regards the Chinese defendant. And that obviously arises only if you're otherwise against me as regards the Chinese defendant. But as regards the Chinese defendant, there's a straightforward, arguable case for infringement of the UK patent against them. There's been no attempt to strike it out, and so there's no Owusu point at all unless you consider that the UK patent infringement claim could otherwise be considered more appropriately brought in China as against the Chinese defendants. And it's not for the reasons we've been discussing. So there is a claim against them for infringement. So you've got to be against me for that, on that point as well. And the point that's put to me, put against me as I understand it, is based upon what my Lord Briggs said in the Lungo case. And it's basically this: does the desirability of avoiding inconsistent judgments enable the claimant in an action who's suing a defendant in the UK as of right because of domicile, does that fact trump everything else? That's as I've understood the judgment. And the law before my Lord's judgment rather treated it as a trump card. And my Lord says that it shouldn't be a trump card, and I'm not going to go through it now, but the key paragraph, I think, is at paragraph 84 of my Lord's judgment, and for your note, it's authorities to tab 36, MS 5113. And what my Lord says
But
is...
it's not a trump card if the UK domiciled defendant agrees to submit to the jurisdiction of the otherwise appropriate forum, i.e. Zambia, which it did.
Indeed.
Yeah.
And it's a factor as well. It's not, I don't think it's a trump card even if they hadn't. It's a factor, as I read my Lord's judgment. And what's noticeable in my friend's cases, is that there's no real attempt to explain how the courts below in this case did treat it as a trump card. It was simply treated as a factor. And we've summarised this at paras 151 and 152 of our case. This is MS 455 and 456. And we say, even if you get that far, and you've got to be against me on a whole load of points where I say the answer is obviously in my favour, but even if you get that far, what the judge did below is entirely consistent with what my Lord Briggs says in Lungo. It's a factor, but not a trump card. Now, I've got to the end of my note. Do you have any more questions before I hand over to Miss Ford?
No, I don't think so, Mr. Speck.
Just one practical one, please. Thinking about country-by-country licensing.
Yes.
Theoretically, the patentee could sue a user of a handset that roams to a country where the license doesn't cover. But
Subject to private use, so that a business person that came in, definitely.
that's not what happens.
It's impractical. You don't know who they are. I mean, it's just unlawful use that is, because you can't, normally in patent actions, all IP actions, it's the person that higher up the chain of supply who's the real defendant, and you can find out who they are and you can stop them. Detecting customers individually is totally impractical. It doesn't make it lawful.
Thank you, Mr. Speck. Yes, Ms. Ford.
My Lords, my Lady, I'm dealing with issue 3, non-discrimination, and issue 4, Huawei and ZTE. Starting with non-discrimination and a few words about the context in which this issue arises. First of all, as you've already heard, the judge engaged in a very detailed and very careful exercise of establishing the benchmark FRAND rate for the portfolio. And his reasoning is set out at paragraphs 170 to 480 of his judgment. So it's some 57 pages and 310 paragraphs. And in the course of that exercise, he looked at various comparator licenses. And the exercise that he did feeds into both the question of what is objectively a fair and reasonable rate for the portfolio and also the non-discrimination inquiry. And his conclusion is set out at paragraph 480 of his judgment. And what he finds is a benchmark rate which he says is fair, reasonable, and generally non-discriminatory. So what he has done, in my submission quite rightly, is he has considered the question of non-discrimination in the round together with all other relevant factors. Secondly, in the course of doing that exercise, the judge made specific findings of fact about the circumstance of the Unwired Planet Samsung license, which is the one that's relied on for the purposes of this non-discrimination argument. Can I ask the court to look at this in the confidential version of the judgment, please? I understand that you should have been provided with a confidential version of Mr. Justice Burse's judgment.
Where do we find that?
May well be so, but can you identify a bundle that will...
I don't believe it's in a bundle. I believe
dear.
it may be separate. perhaps hand some up if it's all gone astray.
Well, if it's not electronic anywhere, what does it look like as a document?
It looks like this.
No. I don't think I've seen it.
No, I wonder if we may have spent it.
Has it not been sent by email?
Appendix 10.
I thought the deal was you were going to hand them up as they came up in the submissions.
Yes.
But
I apologise if it's all gone
I think
astray.
that's right.
No, we don't have this, Miss Ford.
I'm grateful for my letter friend for having some up. For those following in the non-confidential version, it's core bundle 2 from MS724, starting at paragraph 399 of Mr. Justice Burse's document. Partway down this paragraph, he says, before turning to the context in which the licence was entered into, having now analysed the licence itself, it can be said that the terms on their face raise a question mark over this licence as evidence of the fair and reasonable value of the Unwired Planet portfolio in 2016. Even taking into account the uncertainties, the rates are significantly lower than the rates Huawei contend for in these proceedings. And he goes on to make a point that they're significantly lower, and then there's a relevant passage which is blacked out for confidentiality reasons. So his starting point is to say, well, before I look at the context, I'm noting that these rates are lower. He then sets out at paragraphs 400 to 404, to 405, in fact, the evidence of Mr. Ware, who is Unwired's witness as to the circumstances of this licence at trial. And can I ask the court to note in particular, first of all, in paragraph 400, there is a confidential blacking out at the end of paragraph 400. Ask the court to take note of the point that's made there. And secondly, you see in paragraph 404, Mr. Ware's evidence recorded that Panoptis was able to purchase Unwired Planet for a price which did not represent the value of Unwired Planet's patents. In his view, that was because Unwired Planet was on the verge of insolvency. It had told shareholders that it would run out of cash reserves in July 2016, and was desperate to get out of the licensing business to a significant degree as a result of the difficulties Unwired Planet had encountered in trying to license the portfolio and the cost of litigation. So those are the paragraphs summarising Mr. Ware's evidence, and the judge accepted Mr. Ware's evidence as to what happened. You can see that from paragraph 408 of the judgment. He says, I've set out the parties' rival cases because it plays an important role, and he recognises if it is sound evidence of the value of the Unwired Planet portfolio, then I would reduce the fair, reasonable and generally non-discriminatory royalty rate. He then sets out what his findings are. And he says the only licence Unwired Planet had been able to agree was with Lenovo, and Unwired Planet was engaged in very expensive multinational patent litigation in an effort to establish its rights. By late 2015, early 2016, Unwired Planet was close to insolvency, and he says, I accept Mr. Ware's evidence about what happened. The price Panoptis paid for Unwired Planet was lower than the market value of the patent portfolio because of the serious financial difficulties Unwired Planet were in at the time. He goes on to give some more detail on that point. But the key finding in my submission is paragraph 409, where he says these findings about the context of the licence, together with the findings about low rates in that licence itself, support one another. I conclude that the licence does not represent useful evidence of the market value of the Unwired Planet patent portfolio. So you have a specific finding of fact by the judge that this licence doesn't represent useful evidence of the value of the portfolio.
And putting it another way, it's not a close comparable.
Well, that was the way it was put for the valuation purposes, yes. The third point in terms of context is that although much is made in Huawei's case about the difference between the rates offered to Samsung and the rates offered to Huawei, the High Court made a factual finding that the discrepancy didn't give rise to a distortion of competition. And you can see that in the open version of the judgment at paragraph 504. It's core volume 2, page 740. Starting at paragraph 504, you see the judge recording that Huawei had not attempted to conduct the kind of economic analysis which would be required to establish that a dissimilarity between the rates in the Samsung license and the rates demanded by Unwired Planet distort competition. If you turn on to paragraph 517, you see the judge recording that the figures representing the difference between the rates offered to Samsung and the rates offered to Huawei were put to Unwired Planet's economic expert in cross-examination. What he said about that is then set out at the top of 862. He didn't agree that it indicated any distortion of competition, and you can see essentially his reasoning there. He said he was prepared to assume the figures were correct, but explained that one could not draw the conclusion that competition would be distorted, because given the average selling price of the products, the rate is very, very low.
Sorry, which paragraph?
This is the top of page 744, MS 744.
Thank you.
Goes on to explain that what would you have to have done is a detailed analysis. And you have to look at how the market works downstream and how operators set prices. You have to ask what happens to the small price differential. Is it passed on to end consumers, or is it absorbed by Huawei? And even if some of it is passed on, you then have to look at whether customers switch significantly, given that this is such a small share of the market price. That was the evidence before the judge from the economics expert. You can see from 518 that he accepted that evidence. He says, I accept Dr. Neal's evidence on this. Although the relative difference in royalty rates is large, to be considered in the context of possible distortion of competition, they must be expressed relative to the margins on the relevant products. Expressed that way, they are very small percentages. The available evidence does not support an inference that the behaviour complained of tends to distort the competitive relationship between Huawei and Samsung. So the third relevant finding of fact is the judge's conclusion that the difference in rates in issue does not distort competition.
One can see that the judge regarded the question whether there was a distortion of competition as relevant to the non-discrimination requirement. And I can see that that's a point of some general significance. On the particular facts, though, once he had decided that the Samsung transaction wasn't comparable with other transactions in the market, then one might have thought that would be enough in itself to put it to one side.
Well, my lord, I'm going to come on to show you that the judge advanced two alternative approaches. His first approach was what he called general non-discrimination, and in that context it wasn't relevant to look at the extent of distortion of competition, because what you do is look at discrimination in the round with the other factors that inform what is or is not frowned.
Yeah, and the whole concept is based on comparability of situations.
Yes, and in that context it's not necessary then to look at distortion of competition.
And the Court of Appeal did not find it necessary to look at it. Yes.
The only reason we get into distortion of competition, it's really relevant for two reasons. One is the contextual point I'm making now, which is that Huawei's case is you should be giving us the benefit of this rate, even though it makes no difference as a matter of competition. But secondly, the judge's alternative approach was, well, if you do apply this hard-edged, really quite extreme notion of discrimination, then, in his view, it was necessary to look at the way in which that is then balanced out in competition law terms. So, my lords, you have my contextual point, which is that the context in which this argument is being advanced is that it would require the court to disregard the very careful exercise of valuation the court had undertaken, despite the fact that the relevant licence rate has been found to undervalue the portfolio, and despite the fact that it makes no difference in competition terms. I'm turning to look at the meaning of the term non-discrimination, and it's a concept which appears in various different bodies of law. You see it as a general principle of EU law, you see it as a feature of domestic public law, and it's also capable of constituting an abuse of a dominant position under Article 102 of the treaty as a matter of competition law. And in each case, although there may be variations in the way in which the concept is actually expressed, you do see a common theme running through these elements of law, and it's that like cases should be treated alike and different cases should be treated differently. But at the same time, it's important to recognise that the circumstances and the context in which the principle of discrimination can be applied by the court are very broad. At the public law end of the spectrum, it governs the conduct of public bodies in the decisions that they make. And when you apply it in that context, you might well find that you're weighing up considerations of social policy. At the other end of the spectrum, you have competition law. In that case, it's an obligation which governs the conduct of private enterprises. And those private enterprises are engaged in economic activity with other private enterprises. The cases that Huawei have cited in their written case are largely from the public and EU law end of the spectrum. So, for example, Mr. Howard referred to the Franz Egenberger case, and that concerns the principle of non-discrimination as it applies to the Commission, a public body exercising its public functions, and it concerned the importation of New Zealand butter and where importers must lodge their application for an import licence. So it really doesn't have anything to do with pricing conduct of private undertakings. But the obligation that this court is concerned with is the obligation under Article 6.1 of the ETSI IPR policy. And that's very much, in my submission, at the commercial private law end of the spectrum. It's an obligation which is incorporated into a contract between private entities. It's governed by French law, and it governs the activities of private undertakings in their licensing conduct with other private undertakings. So in my submission, the context in which this non-discrimination obligation occurs very much informs the way in which it's going to be interpreted and the material it's relevant to take into account when determining what it means. In the context of the principle of non-discrimination as it applies to private economic actors, in the context of their own economic activity, it's well recognised that charging different prices to different customers isn't necessarily problematic. And in fact, in certain circumstances, it can enhance consumer welfare, and different prices and different terms are commonplace in the real world. We've cited a number of authorities for that in our case. One of them is a practitioner's text, O'Donoghue and Padilla, and I'll just give the reference for that. It's Authorities Bundle 9, tab 172. We've also then shown that the concerns...
Electronic?
I'm sorry, my lord.
Electronic, if you have it.
10160.
Thank you.
We've also shown an authority which shows you that these concerns have been expressed judicially, and that's the opinion of Advocate General Weil in MEO. This is Authorities Bundle 6, tab 112, page 8104. This is a preliminary reference to the Court of Justice concerning price discrimination under Article 102. And if you turn to paragraph 61 of his opinion, which is 8113, you see him making exactly this point. He starts by saying, on a general note, it's important to bear in mind that discrimination, including discrimination in the charging of prices, is not in itself problematic from the point of view of competition law. And he goes on to say the reason for that is that price discrimination is not always harmful to competition, and he refers to the vain attempts made in the United States to repeal the provision in the Robinson-Patman Act, which prohibits discrimination. (62) to say indeed...
Well, he's not saying it's not discriminatory, it's just not problematic discrimination.
My lord, yes. He elaborates on that in 62. He says it's well established that a practice of discrimination, and a differential pricing practice in particular, is ambivalent in terms of its effects on competition. Such a practice may have the consequence of increasing economic efficiency and thus the well-being of consumers. And he says that shouldn't be overlooked when you're applying competition law, and they're quite distinct from considerations of fairness. He goes on to say quite categorically in 63, it should only be possible to penalise price discrimination either under the law applicable to cartels or under the law applicable to abuses of a dominant position, if it creates an actual or potential anti-competitive effect. And he goes on to point out you have to draw a distinction between disadvantage experienced by operators that have been charged higher prices and identification of such an effect, so an anti-competitive effect. The fact that an undertaking has been charged a higher price when purchasing goods or services than that applied to one or more of its competitor undertakings may be characterised as a disadvantage, but it does not necessarily result in a competitive disadvantage. He goes on to say that that's why conduct will only be caught by 102 if it's likely to restrict competition and diminish the well-being of consumers. This is a point which has also been made specifically in the context of FRAND licensing. You can see that in Authorities Bundle 12, tab 236, electronic 12509. This is an academic article entitled Non-Discriminatory Pricing is Standard Setting Different? And what the author opens by pointing out is that there's been a lot of focus on the fair and reasonable, or in this case, reasonable element of the RAND or the FRAND undertaking, and not much focus on what's meant by non-discrimination. If you turn over to 12511, you see the author saying, this is towards the middle of the page, the paragraph beginning most important of the lessons that the economics literature has clearly established is that price discrimination is not always or necessarily harmful. And she goes on to make these familiar points about the fact that it might well actually improve consumer welfare. And she says it's a welcome finding in the context of IP, because price discrimination, in inverted commas, is the norm within IP licensing. And she goes on to make the point. A typical comparison of contracts for two or more firms with licenses to the same IP will generally reveal different royalty rates, terms and conditions. She then makes the point, as long as the patent holder negotiating these differential rates and terms has no market power, there is no need for concern. She then considers the situation, what if that person then does have market power? And that's what she deals with in the following paragraph. But then, if we go down to the paragraph that begins the third step, she says, after establishing market power and possible incentives to harm competition, the third step is a careful and, to the extent possible, quantitative assessment of the anti-competitive effects of IP licensing discrimination. This last step is crucial because even if a firm holds market power and may have the incentive to hinder competition in a downstream market, there are nonetheless a number of efficiency reasons to explain IP licensing discrimination. And she goes on in the rest of the article to elaborate in detail on her point, but she is making the same point specifically in the context of IP licensing and FRAND terms, that one shouldn't proceed on an assumption that a difference in pricing is necessarily problematic. Those sorts of considerations were very much at the forefront of the judge's mind when he was considering what is meant by non-discrimination in Article 6.1 of the FRAND obligation. If we pick it up in Core Bundle 2, page 680, paragraph 175 of the judge's judgment, where he explains what he means. He first defines what he means by general non-discrimination. What he's considering, about a third of the way down paragraph 175, you see the judge saying he's not convinced that the identity of the licensee should be a strong factor in determining what comparables are useful for determining the FRAND rate. He points out that FRAND is supposed to eliminate hold up as well as hold out. Different licensees will have different levels of bargaining power. So he thinks it would be unfair and discriminatory to assess what is and is not FRAND by reference to this and other characteristics of specific licensees. In my view, it would not be frowned, for example, for a small new entrant to the market to have to pay a higher royalty rate than an established large entity. And then he says, in my judgment, the FRAND rate ought to be generally non-discriminatory in that it is determined primarily by reference to the value of the patents being licensed. It has the result that all licensees who need the same kind of license will be charged the same kind of rate. So that's what he means when he's talking about this notion of general non-discrimination.
Can I ask you, I mean, there's an issue here of methodology, but we're talking about the interpretation of some words used in a contract governed by French law.
Yes.
Now, I don't know if the expert evidence gave any guidance as to what the words might mean, but if it didn't, it might perhaps have given guidance as to how you undertake the exercise of interpreting the words. What sort of materials are relevant, for example, to interpretation?
My Lord, there was evidence to that effect. I can give you the references to it. Unwired Planet's expert report is in Appendix 3, Electronic 1517. And there is also a supplemental expert report at 1533. What the court might find particularly useful is at 1534, because Unwired Planet's expert sets out what is common ground with Huawei's expert, and they both agree that in the absence of specific guidance, the French court might make use of any relevant factor which might help understand the provision in question.
Yes, so, for example, if there had been discussions within ETSI forming the background to this, those might be relevant materials, I suppose.
My Lord, yes, and the experts agreed any relevant factor, and therefore one would infer that those discussions are entirely legitimate to have a look at, and those submissions are made in the interventions on behalf of Ericsson and Qualcomm.
Well, I'm just wondering if, rather than looking at economic theory, it might also be useful to look at any materials that actually bear on the document.
My Lord, I certainly intend to take you to that. I would simply like to explain what the judge was doing, because I think there's a risk that when one looks at terms such as general non-discrimination and hard-edged non-discrimination, and one sees that that terminology isn't then found elsewhere, there's a risk that one concludes the judge is doing something in some way out of the ordinary. All he's trying to do in my submission is draw a distinction between looking at general discrimination in the round as one part of the consideration of what is FRAND, and alternatively looking at it in isolation as something which trumps every other element of the test, and that's the distinction he's trying to draw. You can also see that from paragraph 177 of the judgment. He makes the point, which is a pertinent one, that some arguments were addressed to the non-discrimination aspect of FRAND as opposed to the FR aspect of FRAND, as if they were distinct. And he expresses the view that actually it's not that simple. Most of the time, concepts of non-discrimination, reasonableness and fairness relate to one another. So he's making the point that this is all an interrelated concept.
As I understood what he was saying, it seemed to be that you could have had fair and reasonable standing by itself, but that leaves you with quite a broad frame of reference. Having non-discriminatory in there as well gives colour to what one treats as fair and reasonable, rather than leaving it even more widely at large, as it would be without those words.
My Lord, it does, and that's why Huawei is wrong to make the submission, that it has no function in this context. It tells you that when you're asking what is fair and reasonable, you are not entitled to take into account the specific characteristics of the licensee you're faced with. So it's not legitimate for you to say, for example, you're not a member of ETSI, so I'm going to treat you differently. Or I'm going to distinguish on the basis of your nationality, and so what's fair and reasonable for you might be different than what's fair and reasonable for somebody else. You're not entitled, as the judge pointed out, to say, I'm faced with a licensee who has strong negotiating power, and so what's fair and reasonable for you differs than for a new entrant in the market. These words are telling you something very specific about the way in which you ask the question, what is fair and reasonable? But what it also tells you, and this is the point the judge makes in 177, is that you have to consider what is discriminatory in the round together with the other elements you're factoring in. And he's distinguishing that from hard-edged discrimination, which he says, to the extent it exists, is a distinct factor capable of applying to reduce a royalty rate or adjust any license term in any way, which would otherwise have been regarded as FRAND. So he's really not doing, in my submission, anything extraordinary. What he's saying is I'm drawing a distinction between looking at these matters together or treating it as an isolated factor that can override everything else. We turn very briefly to paragraphs 496 to 503. What you see is that the judge had before him some possible different interpretations of the non-discrimination obligation in economics literature. Some of the suggestions were that all users have to pay exactly the same royalty, or a very weak formulation, all users are entitled to a license, but that's it, or all similarly situated firms should pay the same royalty rate. He's setting that out in 496. And at 497, he specifically recognises the difficulty, the practical difficulty which arises in requiring identical rates and identical terms. So he says the standard economic definition, that is one in which all licensees pay identical rates on identical terms, is not supported by either party before me. I'm not surprised. If that is what Etsy undertaking was supposed to mean, it would readily have been written in that way. Impractical in practice. It will be highly restrictive. Many licenses contain most favoured licensee clauses, but they are not generally as onerous as this one. No reason to interpret it in a strict way.
I thought he told us earlier that non-discrimination meant treating all licensees in the same way and varying the price according to the value of the patent rather than the identity of the licensee.
What he's saying is, this is essentially identical rates and identical terms submission. He's saying, consistently with the economic literature that we've seen, that's simply impractical. You can see in 501, he says you shouldn't be introducing the kind of hard-edged non-discrimination obligation supported by Huawei without also including consideration of the distortion of competition. And this is a related point because he says competition law does not seek to prohibit different prices being charged to different customers. An important aspect of the way that result is assured in competition law is by the requirement that only terms which are sufficiently dissimilar to distort competition are prohibited. And he recognises the various elements of competition law operate as a whole to achieve a fair balance. And he quite rightly observes splitting off some parts without the others is unbalanced and risks unfairness. So he's saying, I'm acknowledging the problems of having a rigid requirement that prices be identical. But he then goes on in 502 to say, well, in fact, it's not necessary to read a hard-edged obligation of that nature into the Etsy undertaking at all. And at 503, that in fact, what he thinks the true interpretation of the Etsy FRAND undertaking from the point of view of non-discrimination is that a benchmark FRAND rate should be derived which is applicable to all licensees seeking the same kind of license. That is what I have called general non-discrimination. So he says the preferable interpretation of this obligation is the general non-discrimination obligation. And then he sets out his alternative in the end of that paragraph. If he's wrong about that, if there is a hard-edged obligation, that obligation only applies if the difference would distort competition between the two licensees. So in my submission, the judge's options are essentially two different ways of achieving the same thing. What he's trying to do is construe the non-discrimination limb of FRAND in a way which is workable and practical and consistent with its context as a contractual obligation between private economic actors. And he has offered two ways in which that can be achieved. In my submission, the judge and the Court of Appeal were right to construe the Etsy FRAND undertaking as entailing a general non-discrimination obligation. And I make 5 points in support of that submission. The first is that the judge's construction gives full effect to the duty not to discriminate as it is formulated in the relevant authorities. And the reason I say that is it doesn't discriminate because the rate is determined objectively based on the value of the portfolio. And so it doesn't vary according to the characteristics of individual licensees. And it satisfies the requirement to treat like cases alike because the same objectively determined rate is offered to all licensees who are similarly situated in the sense that they seek the same license. So in my submission, the submissions made on behalf of Huawei, which say that discrimination should be given its ordinary and unadorned meaning, and that like cases should be treated alike, don't actually assist, because the general non-discrimination obligation does achieve that approach. It does satisfy that requirement.
But does it rather undermine the judge's view that the Samsung license wasn't a proper comparable if his reasons why it wasn't a proper comparable were essentially concerned with the characteristics of the licensee, rather than the value of the portfolio which was being licensed?
It was the circumstances of the licensor, I think.
Well, all right,
It was the
licensor.
circumstances of the license, but it is entirely consistent with the judge's finding, because the judge is saying you should be determining the value, the objective value of the portfolio. And he has found as a question of facts that the Samsung license is not informative as to the objective value of the portfolio, precisely because of its circumstances.
If you set the benchmark rate and the patentee then demands a higher fee from a particular licensee, is that discrimination?
Lord, if he's set a benchmark rate, what he has done is he's found a rate which allows fair access to the standard.
Yes.
And so the patent holder would not be permitted to charge a higher rate, because to do so would be to preclude access to the standard at a fair rate. However, I anticipate your lordship may be coming on to ask, well, if he sets the rate lower.
Yeah.
My lord, the answer to that in my submission is the answer which was given by the Court of Appeal in its judgment from paragraph 196 onwards. And the point the Court of Appeal made is that the FRAND undertaking, the function of the FRAND undertaking, is to prevent the SEP owner from engaging in hold-up. So prevent the situation where you can't get access to the standard on fair terms. And it says quite clearly the point of the FRAND undertaking is not to level down the royalty, and it's not to preclude the SEP owner from agreeing lower rates if it chooses to do so.
Well, if I may say so, that's a completely different approach to interpretation. You're looking at what the intention lying behind the obligation is, and you say the obligation, the rationale of a non-discrimination obligation is to prevent hold up, and that being the case, it therefore prevents, it works one way but not the other. Prevents charging a higher fee but not a lower fee.
In my submission, it's a legitimate approach to interpretation applying the French rules, because it's looking at what the ETSI undertaking is seeking to achieve.
Yes, I'm not suggesting it's a wrong approach, I'm just observing it's a different approach from the one adopted by the judge.
In my submission, it's not necessarily different. It's addressing a point that Huawei raised, that Huawei sought to argue that the judge permitted discrimination within a cap, and the Court of Appeal is addressing that concern. And it makes the point that once you've addressed the hold-up concern, once you've ensured that you've got access to the standard on fair and reasonable terms, then there's no point, there's no justification for requiring equal pricing for its own sake. There's no rationale for preventing the SEP owner from charging less if he chooses to do so. And the Court of Appeal was very concerned. It said, conversely, a hard-edged non-discrimination rule, so a rule that you absolutely must charge what you've charged, the lowest rate you've ever charged before, has the potential to harm innovation. It compels the innovator to license at an undervalue, and the Court of Appeal said quite rightly it's difficult to identify any rationale for that sort of rule. So there is a very good reason for requiring access at a particular rate And the Court of Appeal said there is no good reason for precluding the SEP owner from charging below that rate in its discretion if it does so. In the absence of any competitive harm, there's simply no good reason for stopping them doing that.
What was the paragraph in the Court of Appeal's judgment that contains the answer to this point?
My Lord, it starts at paragraph 196, which is at Core Bundle 2, page 530, and it goes on to paragraph 200.
Thank you.
My Lady, I was making the point that the language, the way in which the judge has construed this non-discrimination limb is entirely consistent with the concept of non-discrimination. It doesn't discriminate, it determines the rate objectively, and it treats cases alike because it makes the same rate available to all similarly situated licensees. That was my first point. The second point is that the non-discrimination limb shouldn't trump all other considerations. The courts below quite rightly read the non-discrimination requirement together with the fair and reasonable elements as a unified concept to ascertain a FRAND rate. By contrast, Huawei's proposed construction is extreme because it means that if a benchmark rate has been determined which is fair and reasonable by reference to the objective value of the portfolio, the court has satisfied itself that it provides fair access to the standard. Nevertheless, that exercise has to be completely disregarded because the portfolio has been licensed at a lower rate to another licensee. So it overrides all other considerations, and then it requires the court to give Huawei a license, which it has specifically found doesn't represent the true value of the portfolio. And the Court of Appeal quite rightly found at paragraph 201 of its judgment, this is electronic 531, that the hard-edged approach gives unwarranted primacy to the non-discrimination limb in that license, in that a license granted at a lower rate, no matter how low, will always trump the fair and reasonable rate. The third point is that ETSI considered and rejected a most favoured licensee clause. And Huawei's discrimination argument amounts in effect to an argument that all licensees must be licensed at identical rates and that there should therefore be a most favoured licensee clause. Where we get this from is the TCL and Ericsson judgment, which is Authorities Bundle 8, tab 136. MS 9195. Taken to this a number of times already. But what the US court does here is refer to evidence that was before it about ETSI's discussions. And so this is relevant to my Lord Reed's point about the background to the relevant obligation. We start at page 9206. First full paragraph on that page makes the point ETSI was concerned with price discrimination among potential licensees. It also noted that absent uniform IPR commitments, there shall be a serious risk of distortion of market forces against small and medium-sized enterprises and in favour of large multinationals.
Can I just check, is that Becker's declaration, is that some sort of affidavit? Or?
That's my understanding is the evidence before the court on which it's basing its statements.
Yeah.
You see in the following paragraph, ETSI was concerned about discrimination based on nationality or ETSI membership, but the policy isn't so limited. And they note their concern with protecting small and medium-sized enterprises. And they also demonstrate that ETSI sought to extend the same protections against discriminatory terms and conditions for ETSI members and non-members. Those were some of the elements that I referred to earlier as the effect of the non-discrimination limb is that it tells you that those sorts of factors are simply not relevant to be taken into account when you're looking at what is the value of the portfolio. What is the fair, reasonable, and non-discriminatory rate for it. We go over to the following page, 9207. We see there is at least some guidance in ETSI's consideration and ultimate rejection of the most favoured nations, or here licensee concept. It makes the point that in the 1993 version of ETSI's IPR policy, there was a most favoured licensee provision, and the provision concerned the reopening and renegotiation of existing licences. And you can see quoted there exactly what the provision would have required licensees to do.
And we have that in our Appendix 9, is that
We
right?
do, I
That's
believe, yes. It's
right.
at
Don't
Appendix
worry.
9, 3576. ETSI's members ultimately approved an ETSI IPR policy that did not require such reopening and renegotiation of prior licences. The core version of the IPR policy did not include the most favoured licensee. It says the non-discrimination requirement was still in there. History of ETSI's policy development nor the meagre case law development of the FRAND concept provides the court definitive guidance in assessing whether Ericsson's offers have been non-discriminatory. Go on to 9285. You see the court reiterating the concept of most favoured nation, or here most favoured licensee, was never part of the ETSI-FRAND equation and was in fact rejected. If we turn on to 9293, this is the part where the court starts looking at what might be the appropriate FRAND royalty. See, it says 0.45% is the appropriate FRAND portfolio in the United States. This means that the FRAND rate for Ericsson's portfolio for the rest of the world is 0.314%. If the court then turns over the page to page 9294, you can see that the rates the court has set are then compared in a table with the various comparator rates that it's taken into account. And the simple point I make there is that the court has not simply adopted the lowest rate in the market in setting its FRAND rate. And indeed, if we turn on to 9303, explaining this is the third paragraph down, Dr. Huber concluded that the drafters did not intend non-discriminatory to ensure the same treatment, the exact same treatment or identical license terms for all licensees to the same portfolio of essential patents. Significantly, Dr. Huber was the only legal expert to opine on the meaning of non-discrimination. It necessarily follows that TCL cannot claim that anything other than the nominally lowest rate in the marketplace is per se discriminatory. So on the basis of the evidence before it, the position is not, according to this court, that anything other than the lowest rate in the market is per se discriminatory. What in my submission the court can get out of this judgment is that ETSI recognises and acknowledges that licensees will be licensed at different rates. And that, in my submission, is inconsistent with the construction that's being advanced by Huawei. That was a submission that was accepted by the Court of Appeal, which described Huawei's construction as akin to the reinsertion of the rejected most favoured licensee clause. Two more short points in support of my construction, which I hope to get in before the short adjournment. First is, there is no presumption of harm. For the reasons we've already discussed, there can be no presumption that differential pricing is problematic or harmful. If there were to be a distortion of competition, that can be addressed as a matter of competition law. And that was a matter recognised by the judge in paragraph 502 of his judgment, MS 740, and by the Court of Appeal at paragraph 200 of their judgment, MS 531. But as the Court of Appeal emphasised, if there isn't actually any competitive harm, then there is no good reason why the drafters of the ETSI undertaking would be concerned to constrain the ability of SEP holders to grant licences at lower rates. That's the fourth point. Fifth point concerns commercial reality. The lower court's construction reflects commercial reality in that there will be circumstances where a licensee may well license its portfolio at a rate which doesn't represent its true value. We've identified two possible circumstances where that might apply. The first is first mover advantage, which is where licensees offer lower rates to the first licensee to take a license because it gives them an initial income stream and it validates their portfolio and encourages others to take a license as well. And the second is that a licensor which is in commercial difficulties might engage in a fire sale at a rate which doesn't reflect the actual value of the portfolio. And in my submission, the drafters can't have intended that if, for good commercial reason, you license your portfolio at a rate which exceptionally doesn't reflect its value, the automatic consequence is that you have permanently and irreversibly devalued your portfolio. Huawei says there, well, there's nothing that requires you, the SEP owner, to offer a discount in that way. And the Court of Appeal dealt with that at paragraph 198 of its judgment, and it points out that such an approach is not always commercially possible. So in my submission, that's the fifth reason why this general discrimination approach is the correct construction of the ETSI undertaking.
Yes,
That is a convenient moment. If it's
certainly is. Thank you. 2 o'clock.